Thank you very much indeed, Mr. Speaker, and I beg to move that this House disagrees with all of the Lords in their amendments. Mr. Speaker, this bill is an essential element of our wider strategy to protect our borders and to stop the boats, to prevent the tragic loss of lives at sea caused by dangerous, illegal and unnecessary crossings across the Channel. Mr. Speaker, there are 10 amendments. If I could turn to Amendment 1 first. This implies that the legislation is not compliant with the rule of law. Mr. Speaker, I can confirm that this is not the case. I don't accept that the provisions of the bill undermine the rule of law, and the government takes its responsibilities and its international obligations incredibly seriously, and there is nothing in the bill that requires any act or omission that conflicts with our international obligations. Yes, of course, I'll give way.
Thank the Minister for giving way. He will understand that many of us are deeply concerned that this bill undermines the Good Friday Agreement. Now, I know he has told us previously that that is not the case. He will also know that the Irish Parliament has been considering this matter, and indeed on the 20th of February, the Irish Prime Minister admitted that the government was concerned and was following this debate closely. So, for avoidance of doubt, can he tell us when the government consulted the Irish government about this legislation and the obligations under the Good Friday Agreement, and what the outcome of that consultation was?
Mr. Speaker, I'm concerned with this government and with this Parliament, and in terms of our obligations, there is nothing in this bill that requires any act or omission that conflicts with our international obligations. In fact, this bill is based on both Rwanda's and the United Kingdom's compliance with international law in the form of the treaty, which itself recognises and reflects the international legal obligations of both the United Kingdom and also of Rwanda. I'll give way to the honourable gentleman.
Responds to your questions, at least tries to address the issues. In the past, the last time, Minister, that I asked a question in relation to this, the Minister very tried to answer the question, but the fact of the matter is Northern Ireland, because of our border with the Republic of Ireland, has special circumstances. We were assured at that time that the circumstances of Northern Ireland, as the Honourable Lady referred to the Good Friday Agreement as one example, but also the present purposes of where we are. Can the Minister confirm that our concerns as a Democratic Unionist Party that we put forward at the last debate and have put forward to the Minister himself have been taken on board, because we don't see that in the legislation we have before us tonight, and if we don't see it, then it's going to be very hard for us to support the government in this.
Can I thank the honourable gentleman for his intervention? And I do recall our previous exchange across the chamber, and he may know also of my exchange with his honourable friend, the member for East Belfast as well, and the subsequent correspondence that has happened. The fact of the matter is that the government continues to believe that there is no incompatibility between the bill and Article 2 of the Windsor Framework. I know he's been concerned about that. I hope he was reassured by some of the detail set out in the letter. Of course I will give way.
I must say I'm surprised that the government is not concerned about the incompatibility with this legislation and the clash which it has with Article 2 of the Windsor Framework and the Northern Ireland Protocol, because the High Court in Belfast has ruled that legislation of this nature cannot apply in Northern Ireland because it is incompatible with the obligation which is in Article 2 of the framework to meet with European law.
I do understand the honourable gentleman's concerns. I repeat that Article 2 of the Windsor Framework, there is no incompatibility between that and the bill. He's right to cite the judgment, but of course that is going on appeal, and so it wouldn't be right to debate that further at this stage, but there will be an appeal in that case, and the government's position on this point is very clear, as set out in previous exchanges, and also as set out in the letter which is now in the library of the House of Commons. Yes, of course I would agree.
I do thank the Minister, but but Rwanda cannot just be declared a safe country for refugees by the government making a unilateral declaration in the face of the courts and other independent organisations proving to the contrary. But let me get this straight. Nearly £600 million for just 300 refugees to be sent on a plane to Rwanda. That's an eye-watering £2 million per person cost to the public purse. So does the Minister agree that that is precisely why this political gimmick of a Rwanda bill is extortionate, unethical, unworkable and unlawful?
No, I disagree entirely with all of the points that the honourable gentleman has made, and I know that he is patient. And with his patience, he will hear me responding to each and every one of those points, because the bill is based. Let me take one more intervention, and then I will make some progress.
I thank the Minister for giving way, and he, like me, has always believed that immigration should be dealt with on a UK basis, not on a Great Britain basis, for very obvious reasons. But given the comments we've just heard, would you agree there's plenty of precedent within our own law for deeming certain claims for certain citizens inadmissible? Whilst that applied to the EU, it's not a problem to actually extend that further, because we've already got the principle that we can say a claim is inherently unfounded where a country is clearly safe.
I agree entirely with my honourable friend, and he speaks with great experience and authority, and he'll know other legislation where we have and where we continue to legislate and deem countries to be safe, and I'm very grateful to him for his intervention. Let me take one more intervention, and I'll make some progress.
I'm very grateful to my honourable friend, who's making a good case as to why this Rwanda bill is so important, and the amendments offered by the other place are not relevant to what we're trying to achieve. Does he agree with me? Two things. Firstly, that when people criticise this bill for the cost of sending people to Rwanda, they entirely miss the point that this will act as a huge disincentive to people in families and communities, predominantly in the Middle East, who fundraise at vast sums of money in order for their children to arrive here in the UK, not to end in East Africa. And secondly, that those accusations of cost totally underestimate the actual cost of housing current illegal immigrants in hotels across the country.
My honourable friend is entirely right on both points, and in terms of the deterrent effect, I'll develop that point in a few moments, if I may, but he's entirely right on that, and that is a point that is missed repeatedly by the party opposite. He also mentions the cost of not acting. And not least the human cost of not acting as well. I agree entirely with my honourable friend. The fact of the matter is, I'm going to make some progress. The bill is based on both Rwanda and the United Kingdom's compliance with international law in the form of the treaty. This itself reflects the international legal obligations of both the United Kingdom and of Rwanda. Along with other countries with similar constitutional arrangements to us, we have a dualist approach. And so international law is treated as separate to domestic law, and international law is incorporated into our law by Parliament through legislation. This bill, Mr. Speaker, reflects the fact that Parliament is sovereign and can change domestic law as it sees fit, including if it's Parliament's judgment requiring a state of affairs to be a fact or to be recognised. And this is the central feature of the bill, and many other provisions are designed to ensure that Parliament's conclusion on the safety of Rwanda is accepted by the domestic courts. The treaty sets out the international legal commitments that the United Kingdom and Rwandan governments have made, consistent with their shared standards associated with asylum and refugee protection. Mr. Speaker, we've made it abundantly clear that we assess Rwanda to be a safe country, that we are confident in the government of Rwanda's commitment to the partnership in order successfully to offer safety and protection to those relocated under the treaty. Turning to Amendment 2, I'm unable to accept this amendment. It is simply not necessary. Rwanda has a long and proud history of supporting and integrating asylum seekers and refugees into the region. The government of Rwanda, the African Union and the UNHCR signed an agreement to continue the operations of the emergency transit mechanism. In Rwanda, it temporarily accommodates some of the most vulnerable refugee populations who have faced trauma, detentions and violence. And Rwanda has showcased its willingness and its ability to work collaboratively to provide solutions to refugee situations and to crises as well. And, Mr. Speaker, it's worth reflecting on the policy statement and some of the evidence that has been put forward in relation to this debate and previous debates, because there it's clear that the EU has announced a €22 million support package to the emergency transit mechanism, and the ambassador has said this, that it is a crucial life-saving initiative to evacuate people to safety in Rwanda. It is a significant example, as the ambassador states, of African solidarity and of partnership with the European Union. Of course, I'll give it.
But the point that the Minister hasn't mentioned is that this is a voluntary scheme. The European scheme is a voluntary scheme. Is the government intending the same sort of parameters within this scheme?
In terms of the safety of Rwanda, the ambassador was very clear about his assessment. I'm going to continue the quote, but there are others. There's over 135,000 refugees who are safely in Rwanda and being looked after. And let me just finish the quote. We are grateful to the government of Rwanda for hosting these men, women and children until such time as durable situations can be found. There is evidence, Mr. Speaker, of the safety in relation to the country of Rwanda. Yes, of course I'll give way.
Thank you, Minister, for giving way. You say that you're accepting the word of the Rwanda Foreign Minister that the country is safe, yet our judges in the highest court of our country have decided that Rwanda is not safe. So are you saying that our judges, the highest judges in the land, are wrong?
Well said.
No, respectfully, Mr. Speaker, I'd encourage her to listen to the debate, because those are the words of the EU's ambassador, not any representative from Rwanda, but the EU's ambassador. I think that's a powerful, independent voice, and that's why I cite it here in this chamber. Mr. Speaker, let me make some progress. I will give way further. The implementation of all measures within the treaty will be expedited. Indeed, since our previous debate on this matter, the legislation required for Rwanda to ratify the treaty has passed through both houses of the Rwandan Parliament, and once ratified, the treaty will become law in Rwanda. And the implementation of these provisions in practice will be kept under review by the Independent Monitoring Committee, whose role was enhanced by the treaty and who will ensure compliance with the obligations as agreed. I give way.
Minister, he's been very generous with his time. But would he recall that actually where the Supreme Court judgment hinged on was the issue of refoulement, not the issue of whether refugees were safe in Rwanda or not? And it might benefit some to actually have listened to their judgment.
I'm very grateful indeed to my honourable friend, and I'm going to turn to the issue of refoulement, non-refoulement, and that important issue, which is exactly the basis of the Supreme Court judgment and how we have met it through the evidence subsequent to the time that the Supreme Court was actually looking at the facts on the ground. Because the implementation of these provisions in practice will be kept under review by the Independent Monitoring Committee. And, Mr. Speaker, as is stated clearly in Clause 9 of the bill, these provisions come into force when the treaty enters into force, and the treaty enters into force once the parties have completed their internal procedures. Mr. Speaker, the purpose of the bill is to make clear that Rwanda is safe generally and that decision makers, as well as courts and tribunals, must conclusively treat it as such. The amendments as drafted would open the door to lengthy legal challenges which will delay removal. It therefore follows that I cannot support this amendment. We are confident in the government of Rwanda's commitment, and I am clear that Rwanda is a safe country. Turning to Amendment 3, this is also unnecessary. The government will only ratify the treaty once we agree with Rwanda that all necessary implementation is in place for both countries to comply with the obligations under the treaty. The legislation for Rwanda to ratify the treaty has now passed, as I say, through both chambers of the Rwandan Parliament, and once ratified, the treaty will become law in Rwanda. It therefore follows that the government of Rwanda would be required to give effect to the terms of the treaty in accordance with its domestic law as well as in international law. In relation to the monitoring committee, it was always intended for that committee to be independent in order to ensure that there is a layer of impartial oversight of the operation of the partnership. Maintaining that committee's independence is an integral aspect of the design of the policy. The treaty enhances the role of the previously established independent monitoring committee, and it will ensure obligations to the treaty are adhered to in practice. And, Mr. Speaker, the details of the monitoring committee are set out in Article 15 of the treaty, and it in turn will report to a joint committee which is made up of both United Kingdom and Rwandan officials. There will be daily monitoring of the partnership for at least the first 3 months. That's the enhanced period of time, and that will identify rapid identification and response to any shortcomings. The enhanced phase will ensure that there is comprehensive monitoring and reporting, and that this takes place in real time. Therefore, this amendment risks disturbing the independence and impartiality of the monitoring committee, and it should be resisted. Mr. Speaker, turning to Lord's Amendments 4 and 5, and the issue of Rwanda's safety. And we've already touched on this, but it's clear that the purpose of the bill is to respond to the Supreme Court's concern and to enable Parliament to confirm the status of Rwanda as a safe third country, to enable removal of those who arrive in the United Kingdom illegally. And directly to my honourable friend, the member for Torbay's point, it is the treaty, the bill and the published evidence pack which together demonstrate that Rwanda is safe for relocated individuals, and that the government's approach is tough but fair and lawful. The government is clear that we assess Rwanda to be safe, and we've published evidence to substantiate that point. Of course I do.
I'm very grateful to him for giving way. Just with reference to the point made about the honourable member for Torbay about the basis of the Supreme Court's decision, I'm sure the Minister will, like me, have read the decision carefully. Does he agree with me that paragraphs 75 to 105 make it very clear that there were 3 reasons for the Supreme Court's decision? It was based on evidence, first, about the general human rights situation in Rwanda, secondly, about the adequacy of Rwanda's current asylum system, and thirdly, about Rwanda's failure to meet their obligations in a similar agreement regarding asylum seekers with Israel in 2013. Can the Minister tell me what has happened since the Supreme Court's decision to improve the general human rights situation in Rwanda? He'll be aware that the Home Office have published a 137-page document detailing concerns about human rights in Rwanda, dated January of this year.
Minister.
Well, in fact, that supports the government's position, because the evidence that is put forward actually is balanced. The accusations from parties opposite that somehow there's partisan evidence that's been put forward before this chamber is completely wrong and is refuted by the Honourable Lady's own point. The Honourable Lady herself has just been to Rwanda. The Honourable Lady herself, as chair of the Select Committee, has just been to Rwanda to see for herself. And we had a previous exchange on this last week, and I look forward to her and her committee's report. The answer is the treaty, the bill and the published evidence pack. And there is the conclusive presumption in the bill that Rwanda is generally a safe country. Of course I'll give way to.
My question was this. In January of this year, the British government, through the Home Office, published a 137-page document about the human rights situation in Rwanda, detailing serious concerns from such august bodies as the US State Department about the protection of human rights on the ground in Rwanda. What has changed since the Home Office published that note in January 2024? He hasn't answered that question, and if he can't answer it, then this House cannot say that Rwanda is a safe country.
The answer is that the Honourable Lady mustn't cherry-pick her evidence. The evidence must be looked at in the round. It is, as I say, the treaty. It is the bill and the published evidence together. The Honourable Lady may not have confidence in our international partners to abide by their treaties. This government does. The government of Rwanda is and will abide by its treaty. I won't give way to the Honourable Lady. There is a conclusive presumption in the bill that Rwanda is generally a safe country. There is a series of facts reinforced by statute. The courts have not concluded, Mr. Speaker, that there is a general risk to the safety of relocated individuals in Rwanda. Rather, as we have repeatedly set out, the treaty responds to those Supreme Court findings. The assurances we have had since negotiated in our legally binding treaty with Rwanda directly address these findings, and they make detailed provision for the treatment of relocated individuals in Rwanda, ensuring that they will be offered safety and protection with no risk of refoulement. And respectfully, that responds directly to the points that were raised. Yes, of course, sir.
Is the Minister aware of the UNHCR's comments, which says the UNHCR will build on the favourable protection environment through continued advocacy and technical support to the government of Rwanda? But also it goes on further to say that it's moving from a humanitarian approach to a developmental approach, so that people will be able to have the chance of a livelihood and a safe environment to build their life for the future. Isn't this exactly what Rwanda want to put across to people who find themselves there?
Well, I'm very grateful indeed to my honourable friend, and he proves the point that was just made, that actually it's the evidence in the round that must be considered. I'm very grateful to him for drawing that to the Parliament's attention. I've given way to the honourable lady's wife, so I'll make some progress. We've been clear that the purpose of this legislation is to stop the boats, and to do that we must create a deterrent, and that goes to my honourable friend, the member for Gloucester, and his point earlier on. And that shows, I've already given way to the honourable gentleman, I'm going to make some progress, and that shows that if you enter the United Kingdom illegally, you will not be able to stay. We cannot allow systematic legal challenges to continue to frustrate and delay removals. And I know those on the benches opposite who are supporting this amendment do not mind, Mr. Speaker, if there are continuing legal challenges which frustrate and delay removals, but we on this side are not supporting these amendments. It's right that the scope for individualised claims remain limited. I'm going to move on to Amendment 6. Amendment 6 seeks to enable the United Kingdom courts and tribunals to grant interim remedies. As I've previously stated, one of the core principles of this bill is to limit the challenges that can be brought against the general safety of Rwanda. This amendment completely undermines the purpose of the bill and is not necessary. I will give.
I do thank the Minister, but the Rwanda plan won't work as the deterrent that ministers claim, not least because it will only account for less than 1% of all of those seeking to cross the channel irregularly. So where's the plan, Minister, for the rest of the 99%? And would the Minister not concede that instead of fixing their broken asylum system, the Conservatives have spent an eye-watering £5.4 billion, including over £4 billion on asylum, hotels and accommodation. And that is what is at the crux of the matter, and that's what they need to resolve.
Mr. Speaker, in relation to the deterrence, which I think was the thrust of the question, the answer is this. The Albania scheme that was brought into effect with the Prime Minister back in December 2022 proves the deterrent effect. Those crossing on small boats from Albania, they were down by 90% as a result of that agreement. That shows the deterrent effect. But in relation to Amendment 6, this amendment completely undermines the purpose of the bill, and as a result it is unnecessary, because there are already appropriate safeguards within the bill which allow decision makers and the courts to consider the claims in particular circumstances of an individual person and if there is compelling evidence. We've made it clear that we cannot continue. Of course, again.
I thank the Minister for giving way. Minister, the House will know that I'm the chair of the APPG for freedom of religious belief. So those people who go through the system and go to Rwanda need to have their religious beliefs protected, whether they be Christians, other religions, or indeed no religion. My concern will be when they get to Rwanda, perhaps that protection that they have here will not be as apparent or as strong in Rwanda. Can the Minister give us some assurance that when it comes to making sure that those people who do go will have the same protections for their religious beliefs?
May I say, Mr. Speaker, I know how seriously the honourable gentleman takes this issue. It is an important issue. There is a policy of non-discrimination within the Constitution of Rwanda that will provide some reassurance, and the monitoring committee is also there on a daily basis as well. But I know, and I'm grateful to the honourable gentleman for raising that particular point. Mr. Speaker, we've made it clear that we cannot continue to allow relocations to Rwanda to be frustrated and delayed as a result of systemic challenges in relation to general safety. And, Mr. Speaker, Amendment 7, in order to stop people putting their lives at risk by crossing the Channel, we need, again, a strong deterrent. And whilst creating that deterrent, it's important that the government takes decisive action also to deter adults from claiming to be children. Because it's right to say...
I'm grateful to my honourable friend for giving way. On this particular point, he is of course right that it is essential to make sure that there are protections in place that adults do not masquerade as children for safeguarding purposes for all those concerned. However, he'll be aware, and it was raised in their Lordship's House, that it was in 2022 that the age assessment criteria were to be introduced, and from my divine honourable friend, and these still haven't come into place in terms of the measures that are in place at the border in Dover and Manston. Could he assist the House in really explaining how there can be confidence about the age assessment and how this can be gained with these new measures coming into place?
Well, can I say to my honourable friend, I'm very grateful for her intervention, and I noted some vigorous nodding from behind her by my right honourable friend, the member for Witham, and by my honourable friend, the member for Torbay as well. And she's right. We do need to introduce the scientific age assessments. It's right to say that our European and international friends and allies do so, and we must get that scheme up and running. There's nothing in this amendment that directly affects that or the policy in relation to 2022. So I would encourage her to be reassured on that point. But may I take away her encouragement to expedite that point, and I'm very grateful to her for her intervention, because she's right, Mr. Speaker. She anticipated my point that assessing age is inherently difficult, and there are also obvious safeguarding risks, as my honourable friend has mentioned, of adults purporting to be children being placed within the care system. And it's important that we take clear steps to deter adults from claiming to be children and to avoid lengthy legal challenges to age assessment decisions, preventing the removal of those who have been assessed to be adults. However, this amendment would result in treating differently those who are to be removed to Rwanda to those removed to another country. And we consider that these provisions are entirely necessary, the ones that are already in place, to safeguard genuine children and guard against those who seek to game the system by purporting to be adults. Mr. Speaker, Amendment 8. This House will be aware that the Home Office regularly publishes statistics on levels of migration in the United Kingdom. It's not necessary to report the number of removals to Parliament in the manner proposed. We do not consider an obligation to report to Parliament on operational matters to be appropriate. Amendment 9 would act to impede the provisions already recently passed in the... Of course I'll give one.
Thank the Minister for giving way. Just relevant to the previous amendment that he referred to about the facts that Parliament should be given, could he confirm the reports that were in the paper that the Home Office is now seeking to pay people to go to Rwanda in order to fill the flights? And could he confirm that if people do take up that Home Office proposal, they will be subject to exactly the same payments to the Rwandan government, the very substantial payments to the Rwandan government, and will it also be covered by the capacity questions in the treaty?
Well, Mr. Speaker, that's not directly relevant to Amendment 8, respectfully. The answer in terms of voluntary removals is that, yes, it's in exactly the same way. There were voluntary removals, 19,000 last year, voluntary removals all the way back since the dawn of time, or possibly more. There is nothing new. The novel part, if you like, if the Honourable Lady would care to listen, the novel part is that there will be voluntary removals to Rwanda. That is absolutely right. Specifically in relation to Amendment 8, it is not necessary to report the number of removals to Parliament, and we do not consider obligations to report to Parliament to be appropriate. I'm going to continue. In relation to Amendment 9, this would act to impede provisions already recently passed in the Nationality and Borders Act and the Illegal Migration Act. Mr. Speaker, the amendment is unnecessary. It is important to be clear that the government of Rwanda has systems in place to safeguard relocated individuals with a range of vulnerabilities, including those concerning mental health and gender-based violence. Furthermore, Mr. Speaker, under Article 13 of the treaty, Rwanda must have regard to information provided about relocated individuals relating to any specific needs that may be arised as a result of their being a victim of modern slavery or of human trafficking, and must take all necessary steps to ensure that these needs are accommodated. In relation to Amendment 10, Mr. Speaker, Amendment 10, the Government greatly values the contribution of those who have supported us and our armed forces overseas. That is why there are legal routes for them to come to the United Kingdom. It remains the Government's priority to deter people from making dangerous and unnecessary journeys to the United Kingdom. Anyone who arrives here legally should not be able to make the United Kingdom their home and eventually settle here. A person who chooses to come here illegally, particularly if they have a safe and legal route available to them, should be liable for removal to a safe country. Having said that, I haven't given way to the honourable gentleman. Yes, of course I'll give.
I thank the Minister for giving way, because he did seem to try and brush over some of the costs involved. And is the Minister aware that Virgin Galactic can send 6 people into space for less than this government wants to spend sending 1 person to Rwanda? Is it not time to rethink this absurd policy and extortionate cost?
Directly in terms of costs, we had a debate on Thursday on the costs of the scheme, and, Mr. Speaker, not a single Labour backbencher was there for that debate. There was only the Honourable Lady who proposed that debate, and only the Minister who responded. And, of course, the Honourable Member who moved the motion, who I don't treat as an ordinary backbencher because she's the chair of the Select Committee. It was her debate. Not a single other Labour backbencher was there. That shows the priority, or the lack of priority, which those opposite give to that. In relation to Amendment 10, the IMA passed by Parliament last year enables in Section 4 the Secretary of State by regulations to specify categories of persons to whom the duty to remove is not to apply, whether on a temporary or on a permanent basis. And for those who are not in scope of the IMA, the Home Secretary has discretion to consider on a case-by-case basis where circumstances demand it. Mr. Speaker, I want to reassure Parliament that once the UKSF and the ARAP review has concluded, the Government will consider and revisit how the IMA and removal under existing immigration legislation will apply to those who are determined to be eligible as a result of the review, ensuring that these people receive the attention that they deserve. Mr. Speaker, the Government recognise the commitment and the responsibility that comes with combat veterans, whether our own or those who showed courage by serving alongside us, and we will not let them down. Mr. Speaker, the bill and the legally binding treaty will make it clear that Rwanda is a safe country to which we can swiftly remove those who enter the United Kingdom illegally. It addresses the factual concerns identified by the Supreme Court. It provides for clear, detailed and binding obligations in international law on both parties. It will prevent systematic legal challenges about the safety of Rwanda from frustrating and delaying removals. And it provides a strong deterrent, as my honourable friend, the member for Gloucester, set out, and a clear message to illegal migrants and the criminal gangs that if you come to this country by unlawful means, you will not be able to stay. Mr. Speaker, I beg to move.